Hello all, welcome back to Current Affairs Hit List series. I'm Guna Mathivanan from Officers IAS Academy. In today's video, we are going to discuss about the Protection of Plant Varieties and Farmers' Rights Act. But before that, please watch my previous video where I have discussed a case study connected with this legislation. In the previous case study, we are able to understand the issues surrounding the patent rights given to the potato variety which is being used in the Lay's chips, FL23, right? So the entire case was regarding FL27. Sorry, the entire case was regarding the registration, the patent registration given to the PepsiCo for developing the FL27 potato variety. So here the issue was regarding the rights for the breeder versus the rights for the farmer, right? So the patent which is being given to the plant varieties is entirely different from the patents which we apply regularly for our creative product, right? So what is this patent intellectual property? Please watch my first video in this playlist to have clarity. So the regular patent which we apply for our creative product is different from the patent which we apply for plant varieties. So for the breeder, there is some amount of rights. For farmers, there is some amount of rights. And there was a clash between these rights. Okay. So in that, the verdict was in favor of the farmers. So we need to properly codify the rights of the breeder, farmers, researchers, community. So that codification becomes very important for development of new plant varieties. So what we need is a system. We need a system where the rights of the breeders are protected, the rights of the farmers are protected, the right of the researcher is protected, the right of the community is protected. At the same time, the system should enable development of seed industry as well. The seed industry that also should grow. So we need a proper system. So for which in the year 2001, government came with legislation called as Protection of Plant Varieties, and Farmers' Rights Act. See, this act was introduced by the government to protect the farmers' rights. At the same time, government also wanted to adhere to the international norms. See, India is a signatory of TRIPS, Trade Related Intellectual Property Rights Agreement under WTO. So we are a signatory of an international intellectual property rights protection agreement. So one side we need to protect the innovation, another side we should also protect the farmers' right. So to balance these two, we came with an act in the year 2001. That act is creating a system, and that system is protecting the breeders, farmers, researchers, communities' rights, and also enables growth in the seed industry. So what this act says? So this act says the breeder can apply for that patent for either new variety, completely altogether a new variety, or an extant variety. Extant variety means, see, this variety was in use, but nobody was taking the extracts and claiming some patents. It was in use. So that variety is being used, modified, and a registration is being introduced. So a breeder, we discussed about GM crops in the previous videos. So Bayer, Monsanto, a seed company, right? A seed company, international seed company. So they all together they do research, they come up with a new variety is different, or there is a variety which is existing, people have knowledge about that variety, but they are trying to improve over it and they are trying to have a registration that is called as extant variety registration. So a breeder can apply for new variety as well as extant variety. Even a farmer can also develop a new variety and also an extent variety. I am a farmer or a group of farmers, we also research come up with our own seeds, or we are evolving over time, we evolve seeds and that seeds we are registering as extent variety. Put it simply, breeders and farmers, they can apply for a kind of intellectual property protection. They can protect their product. So if a breeder, so let us say a new variety of potato, is being developed. What are the rights of the breeder? The breeder can produce this potato, can distribute this potato, can sell this potato, can export this potato, will have exclusive rights to do all those things in their brand. They can put a brand sticker and they can produce, distribute, sell, export, share, everything they can do. What about farmers, sir? So farmer can also do that. Apart from that, let us say this farmer, he is buying this potato from the branded company. He is buying the potato from the branded company, and that potato farmer can use, farmer can save, farmer can resow, farmer can share, farmer can exchange, farmer can sell also. But when they sell, they should not use that brand name. So Guna is a farmer. I have purchased the potato. I am using this potato to, I'm using this potato to grow potatoes in my farm. So after that, I am saving some seeds. I am resowing it. I am sharing the seeds to others. I sell my seeds to others without the brand name. Yes, farmer is having the right. Who can use the brand name? Only the breeder. The actual breeder can use the brand. But as a farmer, without putting the brand, I can sell those potatoes. Researchers, without getting permission from the breeders, they can use the registered plant varieties for research purpose. So FL27 potato is owned by PepsiCo. Now I am a researcher. Without PepsiCo's permission, I can get this FL27 and I can use it for my research purpose. Community right. So I am a tribal group. I have protected a particular variety. I have, see, for example, if you have watched this Kalapani Netflix series, where the tribes will be conserving a particular plant variety, but they were conserving it, they were not claiming any right over it. But a new breeder comes, claims right over it. The new breeder is modifying it, and they are trying to register it. In that case, when they register, the tribes will lose some rights. So for the tribes, we need compensation. The compensation will be provided under community rights. So I am a tribal group. I conserve something. Someone is using that. I will be at loss. I will be compensated. Right? Similarly, this system is also trying to promote the seed industry. Indian seed industry is $3 billion worth. So this act is also trying to promote research and seed industry. So to enforce this legislation, this act has brought an authority to enforce the features, whatever we have discussed, the rights, the breeders' rights, farmers' rights, researchers' rights, community rights. This Protection of Plant Varieties Act is setting up an authority. What authority? Protection of Plant Varieties and Farmers' Rights Authority. So that authority will be responsible for providing the registration, for documentation, for maintaining the catalogs for the various plant varieties, for maintaining a gene bank, to maintain all the information regarding the plant varieties, the procedures to be followed, everything or any complaint you want to give, you will go to the authority only. So to enforce this legislation, this act itself is paving way to set up an authority, Protection of Plant Varieties and Farmers' Rights Authority. So this authority, as I said, will be responsible for doing the registration work, documentation work, creating a system in this registration process, maintaining a gene bank, right? The DNA samples of various varieties, plants has to be properly maintained. Everything is authority. Any complaint you want to give, you can go to this authority. The complaints which you give, the authority will listen, the authority will give you a verdict. If you are not happy with that verdict, you can appeal. You can appeal to an appellate authority, and if you are not happy with the verdict given by the appellate authority, you can even go to High Court. You can appeal to High Court. Right? This is what happened in the Lay's chips case. The PepsiCo's registration was cancelled by this authority. Appeal was gone. Then finally it went to Delhi High Court. So Delhi High Court, they also rejected. They said whatever authority's actions, that is correct. There is no issue. So the rejected verdict given by authorities was upheld by the Delhi High Court. That was the case in the previous video which we discussed. Right? So this is about the provisions of the Protection of Plant Varieties and Farmers' Rights Act. So I have given the information here. You can pause the video, you can go through whatever we have discussed. I have given here breeders' rights, researchers' rights, farmers' rights, I have given here community rights, I have given here. Who is going to implement? Protection of Plant Varieties and Farmers' Rights Authority is going to implement. And what is the role, the general functions of the authority? Registration, giving guidelines, providing documentation, creating catalogs. Farmers, community farmers, they need to give some compensation rewards. They will help in achieving, providing that compensation. Protection of plant genetic resource, maintaining national gene bank, maintaining a register of plant varieties. Everything will be taken care by this authority. Right? So any issue also you can take it to the authority. The decisions of the authority you want to appeal, yes, there is an appellate tribunal. You want to appeal the verdict given by the appellate tribunal, you can go to the High Court, any High Court. In the Lay's chips case, the PepsiCo went to Delhi High Court. You can go to the respective High Courts. Right? These are the provisions of the legislation. I hope you got some clarity on this topic. The topic was in news because of the Lay's chips case study which we discussed in the previous video. If you have not watched, please watch that video to get a complete hold on this topic. So tomorrow I will see you with another interesting similar video. Till then, bye. Take care.